Fire. Yeah. You know what I'm saying? So Ryan,
it's down to the real life. And it's and we gotta take it. I just noticed it. Yes. I'm glad to see it. John.
I tried using yeah, they did. Maybe I should.
I like this compass.
Thank you. It's going right there.
Other way, sorry.
See the plumbing?
It's not leaking though, is it?
How are you? Jen was talking to me last night.
Hi, Joe.
My style. Yeah.
Right away. No, I know you are. No, you like what you better.
Someone can see it. we have noticed public hearings. The two of them, we'll be through them relatively quickly. The first public hearing is on Council Order 2016-99. The Quincy City Council is holding this public hearing, June 28, 2016, at 6:50 p.m. in the City Council chambers. Madam Clerk, if you want to.
Thank you. Mass Electric Company requests permission to erect and maintain poles, wires to place thereon together in such sustaining and protecting fixtures as said company may deem necessary and following public ways or ways. Mechanic Street, install SOS P6130 4-2 Mechanic Street, located approximately 71 feet southeast of T5 pole, required to provide electric service to new building at 22 Mechanic Street.
Is there anyone here wishing to speak publicly in favor, in support of this particular matter?
Mr. Chair, is there a representative from Mass Electric?
Yes.
Representative from Mass Electric, why don't you come on up? Some important information you want to share with us? Or you just here to answer questions?
Yes, to answer questions.
Oh, I got to turn my microphone. You want me to do that? I'm going to turn everyone's microphone on, and that way I don't have to remember to turn it on before you speak, so FYI. It's on. Go ahead, you're good.
Evening, Councilman. I'm just here to answer questions. Requesting pole location to serve new building at 22 Mechanic Street.
And could you please state your name for the record?
Sure, Jim Pearson, Senior Operational Engineer, National Grid.
Thank you for being here. Appreciate them sending someone. Anyone wishing to speak in favor? Anyone wishing to sign in favor? Come on up. Anyone wishing to speak against? Anyone wishing to sign against? All right, we're going to call the we're going to do a roll call vote on the order 2016-99. Madam Clerk, you want to call that up?
Point of order, is it? This is a public hearing.
Yeah, she's telling me to vote on it.
Does it simply go back to committee and we bring it out to the next council?
On the next one.
Right.
All right, so we'll go to the second public hearing, 2016-100. Public hearing set to begin at 6:55. We're a little late on that one. Madam Clerk, if you'll read that for.
Yes, Massachusetts Electric Company requests permission to locate manholes, wires, ducts, including the necessary sustaining and protecting fixtures along the following public way. Temple Street, install 4-inch conduit concrete encased from 24 Temple Street, Patriot Ledger property, 40 feet north across Temple Street to 1306 Hancock Street to feed new transformer pad for church, as well as to install manhole 79-1 in public way to serve future lights.
All right, what are you doing?
Yes, I guess MassDOT, as part of the Adams Green project, is also doing work on Temple Street. They're going to be feeding lights over there. We don't have any secondaries in the street. At the same time, the church, and they've been requesting this for a while, they're going to be putting a new transformer to serve the church. I guess they're going to be putting air conditioning in there. And they've asked us to serve them. Originally, we were going to come across Hancock Street, and the city asked us, could we come off of the Patriot Ledger property, which we're going to get an easement, come across the street to serve the church. We said, fine, as long as you get us the legal easements from the Patriot Ledger property, which is being worked on as we speak, and an easement from the church, so we can serve them as well as the lights that are going to be erected up on Temple Street. So that's the reason why we're here today.
Lights, got it. All right. Calling anyone wishing to speak in favor of this order, come up now and speak. Anyone wishing to sign in favor or support? Seeing none. Anyone wishing to speak against? Anyone wishing to sign against? All right, I'm going to call this public hearing on 2016-100 to a close. sir.
Thank you, sir.
Thank you very much.
Appreciate you coming. They don't always come.
Yeah, I just found out, we're gonna take care of that
Thank you.
problem.
Appreciate that. I'm going to call to order the Oversight Committee meeting of April 28th, 2016. Madam Clerk, if you would call the roll.
Counselor King.
Present.
Counselor Crowe. Counselor DeBona.
Present.
Counselor Finn.
Present.
Counselor Harris.
Present.
Counselor Hughes. Counselor Flores.
Present.
Counselor Yan.
Present.
Counselor Palmucci.
Present. All right. Counselor Kroll had texted me earlier. He's been battling the cold, so he wasn't going to be able to make it. Counselor Hughes had some previously scheduled commitment, some board business in Ward 5 that she had to attend to. So neither of those folks are with us tonight. Just by way of kicking things off, we're here in consideration to have a hearing on two matters pending for the Quincy City Council. The first is 2016-15, which was a resolution introduced by Councilor Joe Finn and Councilor Noel DeBona relative to the misclassification of employees on construction sites. Thank you, Madam Clerk.
Thank you.
The second matter that this body will be considering is 2016-74, introduced by myself, which is an amendment to the Section 9 of the zoning ordinances. I think folks on the committee recall we had a previous hearing where we received a presentation from the Carpenters Union and testimony from several folks. This is a continuation of that. I've invited a couple of guests to speak to us tonight and have a conversation with us about this issue to help shed light on the issue so that we can be better informed prior to taking any official action on any pending matters. Does anyone have anything they want to say before we get started? Seeing none? Okay. See, if I was sitting out there, I'd have something to say. That's how it works. All right, so first, from Attorney General Maura Healy's office, we have Assistant Attorney General Cynthia Marks here. You want to come up and maybe introduce yourself and tell us a little bit about what the Attorney General's office does, what roles they perform in this venue, and what kind of things you're working on.
Sure, thank you, Chairman Palmucci. Can you hear me?
I can.
Okay.
I don't know how to make it loud.
Thank you for inviting me tonight. Thank you to the city councilors. I'm sorry I was not able to be here for the first hearing on this matter, but I'm happy to be here today and appreciate your flexibility. My name is Cynthia Mark, M-A-R-K, no S.
Sorry about that.
That's okay. And I am Attorney General Maura Healy's chief of her Fair Labor Division. The Fair Labor Division of the AG's office enforces state wage and hour laws, and the primary laws that we enforce are non-payment of wages, prevailing wage laws, minimum wage laws, and overtime laws. We also enforce child labor laws, earned sick time, domestic worker bill of rights, domestic violence leave act, and of course, we enforce the misclassification law, which I'll talk more about later. The Fair Labor Division also has a bid unit, which hears appeals pertaining to public construction bidding laws. And our bid unit ensures that the process by which public construction contracts are awarded is fair and open, free of corruption and favoritism, and that public construction awards go to the lowest eligible and responsible bidder. So lastly, I'll talk about the state's misclassification laws. And misclassification occurs when employers classify their workers as independent contractors rather than employees, when they should be employees. I know that you had a hearing before and that you probably heard some statistics, and we haven't had any recent studies, but there's a 2005 study that shows that in Massachusetts, they estimated that 25 to 39% of workers in Massachusetts are misclassified as independent contractors. So who are these misclassified workers? They can be cleaners, janitors who are cleaning buildings, nursing homes, grocery stores. We've seen workers who are asked to purchase a cleaning franchise and to buy their own workers' comp insurance. The franchisee may consist of only one or two or a handful of workers, and the contract to clean might not even cover minimum wage and overtime and out-of-pocket expenses for these workers.
Ms. Mark, if I could, just how do you prefer? Do you prefer to make a presentation and then have questions afterwards, or would you encourage
Well, I'm
questions?
prepared to, I'm prepared to give a presentation.
Okay, so we'll do that then. I just wanted to ask this.
Okay.
I'll write my questions down.
If you have questions, you can feel free to jump in. I don't mind.
All right, thank you, sorry.
Sure, no problem. Other workers who are misclassified are, commonly are nail salon workers. They are required to be at a nail salon all day long, but they are only paid whatever the customer pays them minus maybe 40% that goes to the owner of the salon. And in a good shop, these nail salon workers might make enough to cover minimum wage and overtime, but in an oversaturated market, they will not ordinarily be making minimum wage or overtime. And then, of course, I know that there are a lot of folks in the room who are construction workers, and it's also very common in the construction field for laborers, painters, drywallers, who apply for a job and are told if you want a job, set up a company, buy your own workers' comp insurance, and then we'll give you work. So who are employees legally, and what's the legal standard? It's governed, so the statute that governs independent contractors and employees is Section 148B of Chapter 149. And workers are presumed to be employees. So the vast majority of workers should be employees. If an employer classifies a worker as an independent contractor, the employer has the burden of proving three things. The first is that the individual is free from control and direction. 2, the services performed are outside of the usual course of the business of the employer. And 3, the individual is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as the service performed. So, for instance, I just talked about cleaners. So if someone's in the business of cleaning and has like 10 contracts to clean, at the grocery store, at a market, at a restaurant, that person might be properly classified as an independent contractor because they can decide whether, what time they want to clean the market or how they're going to clean the market. But if you have a cleaner who works 8 hours a night for one market, and they're not in the business of cleaning for other businesses, that's their job is to clean for this one market, then that worker should be under the law should be classified as an employee. So what's wrong with misclassification? So independent contractors are denied basic labor standards protections such as minimum wage, overtime, and prevailing wage, and also a right to be paid, weekly or biweekly. They have to pay they have to pay double FICA Medicaid taxes because normally, an employee pays like half of FICA and then the employer pays half, but if you're an independent contractor, you pay 100%. And independent contractors are generally denied access to safety net programs like unemployment compensation, workers' comp, and employer-provided benefits like health insurance and pension plans. And governments and local communities also suffer from reduced revenues. So governments will have less money to pay for safety net programs like Medicaid or hospital-free care when employers misclassify and don't pay into these safety net programs. Because if a worker needs unemployment insurance or needs workers' compensation and they prove that they are in fact an employee, the worker will get those benefits, but the money will come out of a trust fund, which is funded by responsible employers. So I really, misclassification is a growing problem, not only in Massachusetts, but throughout the country. And I really commend Quincy for holding a hearing on this important issue. So what is the Attorney General's office doing? We're aggressively enforcing our wage and hour laws. We get over 5,000 complaints a year. In the first quarter of this year, we issued citations totaling $326,000. Last year, we issued citations of almost $700,000 in restitution and penalties. But these citations are really just the tip of the iceberg. So we're trying to be creative, and we're trying to sue employers who violate our laws by bringing false claims acts against them. We have civil and criminal authority to sue, and so we're looking at repeat offenders who intentionally violate the law for criminal prosecution. And we're working with other state and federal agencies who are willing to partner with us, like the city of Quincy. So what can Quincy do? What can Quincy do to stop misclassification and wage theft? As an awarding authority on public construction contracts, you can be careful in checking the references of all contractors who bid for public construction work. And beyond the references that are provided, you can investigate subcontractors to make sure that those who submit bids are responsible employers. You can choose responsible bidders who do not have a history of wage theft. You can collect certified payroll records and review them to make sure that workers are being paid the proper wage. And if you suspect wage theft or improper payment of wages, please report your suspicions to the Attorney General's office. You can also support an act to prevent wage theft. This is a bill that was formerly Senate number 966, and it's now Senate 2207. This bill would hold general contractors responsible for wage theft by their subcontractors. It would allow the Attorney General's office to issue stop work orders upon the finding of wage theft. And it also allows the Attorney General's office to go straight to court and to file a civil complaint seeking treble damages, attorney's fees, and costs. And this is something that private litigants can already do. The third thing that the city of Quincy can do is, many cities and towns around the country are passing wage theft ordinances. This week, Chelsea just passed a wage theft ordinance, and in 2014, the mayor of Boston signed an executive order that requires city contractors to sign a certification that they comply with wage and hour laws, and that they have not, if they've been found to have violated wage and hour laws, they have to disclose it, and they may be required to put up a bond, or they may be denied a city contract. They may also be denied a license. So I'm happy to take any questions that you may have.
Sure, I have some questions. So, I suppose when I sit here, I have to let other people go first. Well, I don't want to be council president. Well, why don't I start over here? Do you have to go?
I do, I have.
All right, if you don't mind, I know it's, you guys offer this, but can I start with Councilor Forrest, who has another engagement?
I appreciate the yield, Councilor Fenn. Of course, I have a couple of other appointments I can't miss this evening as well. I guess I appreciate you framing this, and I should reference Attorney General Mara Hill, who's in Quincy City at one of our veterans ceremonies. It's very much appreciated. It's great to have you from her office. In the district I represent, a nonprofit organization has had a project, and they testified before us last time that some of the employees were subcontracted and were saying we haven't been paid, and they came to us with that information. And so what you're saying is if we pass this wage theft ordinance, it would hold, so the contractor on the job says, it's not my problem, I paid. The subs employees or independent contractors are saying we didn't get our money. So this wage theft ordinance would hold the GC responsible for anyone working for that sub.
The wage theft bill that I just mentioned is, it's a state, proposed state law, and it would hold general contractors responsible for wage theft of their subcontractors where there is a significant nexus. So there needs to be, a connection. Well, the magic words are significant nexus.
Okay. And one of the things you had talked about, what the city could do as far as checking references of all the contractors and and the subcontractors as well. And we can, that's allowable for us with those subs today as a municipality? How does that work?
So my understanding.
So we vet the contractor. My understanding is we vet the contractor, and then we find contractors bringing on some subs that aren't wouldn't meet quality standards of Quincy. So how do we prevent that going forward, or how do we?
So my understanding is that there are different kinds of subs. So there are some subs who submit bids, and they provide references, and they should be able to be checked. Like there should be a way to check to see if they're a responsible contractor.
Responsible employer.
Right. But I understand that general contractors can also hire their own subs who haven't submitted bids.
Correct.
So that could
That's
be
the loophole.
that could be a
we're looking
weak link.
Okay, that's the loophole that I have some concerns about. And then second, you had talked about how the city can do their homework relative to these responsible employers and whether they meet the community standards. And where would one find that information? So for example, hypothetically, a contractor is working on a job, concerns are coming into us, and we want to do some homework. Geez, what is the deal with, let's do some fact finding. Where would the municipality find that information?
Well, on the AGO website, there are bid unit decisions. I don't know how far back those decisions go, but you can search by employer. So, it doesn't show every employer. You could also call our bid unit to talk to Deborah Anderson, who's wonderful. She's like the expert on the bid work.
And I guess my other question is, you had talked about last year you had issued $700,000 to contractors or subcontractors in the Commonwealth. And for those who have been fined and there's been violations from your office, where would that information be available?
So we're working on getting that information posted publicly, but it's not yet public. If you wanted that information, you would have to do a public records request.
So like a FOIA.
A FOIA, and you would just give some parameters on what you're looking for, like construction industry citations in 2015.
Okay. I'm going to hold some other questions. We are having our audio being recorded, but not, QATV's not here tonight?
I don't know. Nobody tells me things.
No. Okay, because I'm very curious about this discussion and wanted to double back. Mr. Chairman, I'll connect with you.
We'll also be having a third hearing.
There will be a third
There will be
hearing.
a third hearing.
Okay. Thank you.
At least a third hearing.
Thank you.
Thank you, Councilor Ford. Councilor Fenn, did you want to follow?
Yeah. Thank you, Mr. Chairman. Well, I thought you put them all on.
Yeah, well, someone said they didn't.
Exactly. But thank you, Mr. Chairman, for holding these hearings. This is a very important issue from my perspective. Again, particularly it's important, you mentioned the last study was 2005, no long overdue. It's time for another study, quite honestly. Because even in my career, I started here in 2001, but it seems, to me at least, that the number of questionable construction types of projects that are going around have grown significantly over the past decade. And this is a very critical issue for us at this point in time here in the city of Quincy, because we have a significant amount of construction that's occurring specifically of rather large-scale residential properties. And again, eventually, we hope, of some commercial properties. And it really is so concerning to me as well, particularly from the other function that you talk about that comes under the Attorney General's office, and that's around a fair bidding process. And as you said earlier, to make sure that it's free of corruption and favoritism, and also to the most qualified lowest bid that's there. But it's this very problem that is skewing that entire process. And this is not simply an organized labor issue. This is a fundamental business issue. People are cheating, plain and simple. And that as a result, what happens oftentimes, there are bids, and bids that are accepted perhaps, that no longer account, one, for fair and just wages. In fact, the testimony we received last time, certain people never get paid. But it also ignores certain things related to health care and other specific issues and how it impacts. It affects the taxpayer. It affects the safety on the workplace. And most importantly, at the end of the day, the work is not going in a fair manner or in an uncorrupt manner. It's going to those who cheat. Bottom line. And I'm very concerned because in relation to the level of oversight, we do want to know what we need to do here, not only to have a proper ordinance in place, but also the ability to enforce that, to have teeth in it, so that we don't allow those kinds of practices to continue. And I guess one of my questions would be, particularly in terms of the trades and construction trades, do you have any data, complaints that you've received at the AG's office, and the number that you've actually been able to investigate and act upon?
I don't have those numbers with me today. I can get those to
I think those numbers would be helpful, because I think it, again, points to a significant enforcement problem and issue. I think that whether you have the resources or not, I can't begin to speak to, but that's got to be a key part of correcting the trend. It's interesting to me that, I guess the other question is, you mentioned you're working in partnership with federal and local governments. Like, what are you doing specifically around trades together with federal government to address this problem, or to really change the direction things seem to be going in?
Well, just a few points of clarification. I did mention a 2005 report, and I just want to be clear that that was not a study by the Attorney General's office. It was a study that came out of Harvard, and so it was an academic study. And I agree with you that we need a new study.
Well, you need other data sources.
That's very, it's a very.
I think a good place to start, I'd love to see, would be the number of complaints you receive and the number of complaints that are acted upon. I think that would be
Well,
helpful.
I can tell you that the construction industry, complaints that concern the construction industry are a priority for the Attorney General's office. It's absolutely a priority. We get a large number, and the cases that we investigate are at a higher rate than the general, than the non-construction complaint. So we know that there are a lot of violations happening in the construction industry, and we're prioritizing it. That said, we absolutely don't have enough resources to do all of the enforcement. And there are many barriers to citing someone. We need workers who are willing to talk to us. We need witnesses. I've been with the Attorney General's office for 6 months, which is not a long time, but in 6 months we've hired 6 new investigators, and 5 of them are multilingual. So, we want to reach the most vulnerable workers who are, susceptible to abuses. So if people, have not been paid their wages, they should be filing complaints. And we're trying, we're working, I said we're working with the federal, USDOL to really try to maximize our impact on problem industries and, on certain practices like misclassification. So we participate on the Council on the Underground Economy, which is, it's a gathering of various state agencies and federal agencies to share information, so that we're not duplicating efforts. Is it enough? No, it's not enough.
You had mentioned the phrase, the concept of significant nexus, again related to certain contracts or subcontracts. Could you speak a little bit about that more specifically to how that might apply to the construction trades in some way? What's happening and perhaps what some of the difficulties might be?
Well, that significant nexus language is in the proposed bill, and so it's not something that we are currently able to use to enforce our wage laws against, to enforce our wage laws against subcontractors and general contractors, so that we can impose joint liability. That's not something that we have yet, but it's something that's a bill that's currently.
That would be absolutely critical, though, is putting that emphasis back on the general contractors.
It would be a game changer because it would make general, the city councilor here, I think, said before that, general contractors, they say, well, those, like we pay the subcontractor. If they don't pay their workers, then I don't, it has nothing to do with me. But this wage theft bill, if there's a significant nexus, would make it the general contractor.
Now, would that, the bill as well as it moves forward, would that also include specific development interests that are hiring these contractors or hiring these subcontractors, and you have all these various tiers? Is there some kind of link to some of the developers themselves that are coming into this area and hiring specific contractors?
Well, it's hard for me to predict how far it would be applied because it's not even law yet, and so it hasn't been applied or challenged.
I guess, and again, I will plead a certain level of ignorance about some of this stuff, but it's kind of disturbing, just even in recent days, that, the very delicate issue between what I consider to be advocacy and what others refer to as extortion is at play. And it seems that specifically that great deals of attention have been paid. We've heard about wiretaps, and we've heard about all of these other different things, particularly when people are talking about things that guarantee freedom of expression, such as pickets and things like this. And so much, it seems a lot of time and resources is spent in relation to this. And yet we have this particular problem that's costing millions, if not billions of dollars. Where are the federal investigations of this? Where's the focus on that? And at the end of the day, when you get to the bottom of it, there's no greater threat to our capitalistic liberal society than the level of greed that's out there at play in the midst of this. And so what we're really trying to do here, what we're trying to do structurally this legislation, is how we can best work in cooperation with you and structure a local ordinance here that allows us to hold all of those people who come before us for permits or for rights to do certain things or to build or whatever, that we can hold them accountable to some basic standards that we believe are very important here in the city of Quincy. Quincy is the birthplace of the international laborers, right over on School Street. That's part of the tradition of who we are. And it's disturbing to me when I'm certain that there are people out there who tell me at least 3 active projects right now where the classification and the payment methods that are being utilized are probably somewhat sketchy. And it just seems that the more light we can shine on this, the larger amount of attention we can bring to it is absolutely critical and important. Again, I'm very grateful for the fact that you're here. And I know the chairman has also proposed some initial amendments to our special permit process to begin to address some of these things. But we also need to think about how we're going to enforce this. Because as I said, in my mind, in the last decade, it's grown tremendously. And I'm sure there's people out here who could share stories about it. But thank you.
Thank you, Councilor Finn. Any other councilors wishing to be here? Councilor Leanne.
Thank you, Mr. Chair. Ms. Mark, I want to thank you for being here today, and again to Councilor Quinn and Councilor Devona for bringing this issue to light for all of us here as councilors to educate us on this issue, and then also be able to share some information on how we can actually be effective in addressing it. And so I wanted to talk to you about the enforcement. Again, just going off of what Councilor Finn said here. You've given us some really good ideas on how a first step to that is putting together a really solid ordinance that any developer, any contractor doing work in the city of Quincy will have to follow. And so those are some good guidelines that we could set up for the future and projects coming down the road. I wanted to talk to you and pick your brain about some things we can do right now for the construction that's currently going on in our city, for the workers that are currently doing work across our city, what we can do to encourage them to either speak up, to report. So if you can sort of speak to how streamlining that process works, like if there is somebody out there right now that is, seeing something that's wrong and isn't really sure what the reporting process is going to be, do they call somebody in the city? Do they call the AG's office directly? Can you just sort of speak to how that process works, and so they have an understanding of what's going to happen if they do decide to have, the ability to step up and make that phone call?
Sure. I mean, individual workers can file complaints with the Attorney General's office online. There are online complaint forms. We get complaints from workers, from anonymous tipsters, from unions, from city councilors. If somebody has information about wage theft, you can file a complaint online, or we have a fair labor hotline. I don't have that number in my head, but if you go to our website, I'm sure you'll find it. And the hotline can provide information to anyone who is concerned about payment of wages.
And that would be anonymous, just to protect somebody's identity, because I know, unfortunately, a lot of the people that are victim to this misclassification and, the negative effects that come with that aren't in a place where they can necessarily expose themselves in fear of not being able to get another job, in fear of, being shunned and not being able to work, and keep food on the table.
Calling the hotline is anonymous. You don't have to give a name, and the names are not even recorded. Making a complaint, you can file, someone can file a complaint anonymous, but at some point we're going to have to speak to somebody. We're going to have to be able to talk to someone and investigate the claim. And if the employer doesn't just voluntarily agree to change its practices, we may have to take that case to an administrative hearing or to court, and we'll need witnesses. So an investigation can happen, like an initial investigation can happen without disclosing names, but at some point we'll need people who are willing to stand up, to speak up for their own rights. That said, our statute also has anti-retaliation provisions in it, and I know that, if an employer's flouting the law, they may flout the anti-retaliation provisions as well, but it's there, and employers can be sued for retaliating against workers who are complaining about whether or not their wages are legal, or whether or not they've been misclassified.
And just again to go back to what we can do on our behalf and on our side of things. So I'm just trying to play this out and see situationally how this would work. So if, let's say, during construction of something in the city of Quincy, an employee comes up and reports that this is happening on, and there's a stop work order that's issued to that project, is then that project that completely come to a stop, the entire thing, and there's no really sort of time frame to how that's going to be. So I just want to have an understanding, because if somebody comes to us and we report it, I want to be able to say, okay, well, since you're reporting that, we do have to look into it. You know, this big project on this property is going to come to a halt, and you know, I just, again, want to understand what that looks like and how long that process generally takes, just to have an understanding of, do we then say that that contractor is out of the project and we can open it up to a new bidding process to have somebody else come in and do some more work? You know, I just want to understand how that looks.
Sure, so I just want to be clear that right now, the Attorney General's office does not have authority to stop work on any job for just like a straight wage theft allegation. The Division of Industrial Accidents does have stop work authority, and they issue over 2,000 stop work orders every year. The Division of Industrial Accidents is part of the Council on the Underground Economy, so you know, we work with them and collaborate as far as we can. I believe that ordinarily those stop work orders are not in place for very long, because it's the issue is whether or not the employer has workers' comp insurance, and they can buy it if need be.
Thank you.
Thank you, Councilor Leon. Any other councilors? Councilor DeBrun.
Thank you, Mr. Chairman. Just elaborating on both my three councilors actually that have been speaking. I'm looking for a few questions that I have for you. Thank you for being here tonight. Appreciate it. You talked about 5,000 citations, right? You said $326,000 for those citations. Do you have an idea of where the majority of those citations are going to? What cities, towns, contractors? Do you have any of that off the top of your head?
I don't have that information off the top of my head now.
Where does Quincy fall into that area? How much enforcement is being going on in this city? Is what I'm really getting to.
So I can't speak to any active investigations. We just don't talk about active investigations. When I did look at citations in the last month, I found one that was an employer was cited for work that was being done, I think, at Quincy City Hall, was cited for about $200,000.
Right here in this, what you said?
I guess so. I guess so.
I don't know if you knew there was copper stolen around here as well.
No, I didn't know that.
Basically, how do we as a city clean up what's going on? How do we as a city, how do we as a municipality, how do we as a body clean up our own backyard, basically?
I mean, I think that this is a really important start, that you're talking about the issues and you're looking into it. It's really important for you to acknowledge that, you know, wage theft is a problem in your city, and to be looking for solutions. And so even like how you issue bids, when I was talking to our bid unit attorney, she said that a lot of times that invitations to submit bids, they come out and they invite subcontractors, you know, they submit their bids first, and then a week later, the general contractor submits its bid. So it's a 1 week difference. So when you only have a 1 week differential, there's not a lot of time for Quincy to check into, you know, the sub bidders' credentials, you know, to see if they're a responsible bidder or not. And the other thing is to find a way to make sure that the general contractors that are hiring subcontractors directly, not through the bidding process, that they're hiring responsible subcontractors.
Now, you talked about you take the lowest bid. Now, do the other contractors know what the bid is or not?
I don't think that they know before they put in their bid. Like, you're putting in your bid,
Right.
which is your best bid.
So if there's 10 contractors bidding, does any of the 10 contractors know who everybody else is bidding on? Like the amount? How do you get to that level where, what I'm trying to say is, how do you get to the level of where everybody knows what everybody's bidding?
Well, so you know when the bid's been awarded.
Okay.
So once the bid's been awarded, a responsible contractor who has not gotten the bid can file a protest
So,
and say, well, that low bid is not valid for X, Y, Z reasons, and, you know, one of those reasons could be that they're using non-responsive, you know.
I'm just basically kind of referring to that's probably the best way of even playing field for everybody, I would think. Don't you think you would agree with that?
It's a leading question. There are many ways to.
You have my permission to treat him as a hostile.
Well, you know, we'll get a little bit to more of the enforcement here. Who is allowed to go onto these work sites? Is a regular citizen from the city allowed to go on the work site and take their phone and start videotaping, hey, listen, this looks wrong. Can that be done?
I'm not a property expert, and I can't say, I would imagine that work sites are dangerous places, and that who goes on a work site would be highly regulated, so I would.
Maybe just like across the street from a work site and being able to not be on the property, but be able to see what's going on. Can you audio or videotape it?
That's not my area of expertise.
Jeez.
But I don't know why not.
Okay. The only reason why I ask is just, I'm big on the enforcement issue. How do we really enforce all these, like misclassification, the lowest bid, all these different data that we're going to need? Because the bottom line is just to have a fair opportunity for everybody at the table, basically. That's really for me, Mr. Chairman.
Thank you, Councilor DeBona. Councilor Kane.
Thank you, Mr. Chair. Thank you very much for being here, Mr. Mark. That just piqued my curiosity. I would like to know, I guess, when you are issuing fines and the restitution of penalties, what is the process? How do you discover that these offenses are being made?
I mean, from a variety of sources, as I said, you know, sometimes the unions are the ones who are filing complaints with us. Sometimes it's workers. Sometimes it's competitors losing contractors. You know, they file complaints and say, you know, the guy down the street is doing X, Y, Z that's illegal. So if we look into it and there are witnesses and there's evidence of wrongdoing, then we will cite, or we will, you know, work out an agreement with the employer to pay their workers what they should have been paid.
And so any report that comes in is looked into, and then what's that sort of, that level, you know, that, at what point do you actively engage in the investigation?
So, as I said, we get over 5,000 complaints every year. We may look at every complaint, but we cannot investigate every complaint that comes in. So we investigate complaints in strategic areas that we've identified, and construction is one of those strategic areas. That doesn't mean that we can investigate every complaint involving a construction company.
And you said you've been there for 6 months. Can you just hire a couple people on the team?
That's right.
And so what's the total number of team?
We have, I think, 17 investigators and 12 attorneys
17 investigators plus 12 attorneys.
statewide.
Statewide. Okay, so we stretch very thin.
Yeah.
And do you anticipate increased funding coming down the pipe?
We didn't get our funding increase with the last budget.
Okay. So then in terms of doing your job, advocating in forms like this, very, very tough.
You can answer.
We are. I mean, we are. You know, employment rights, workers' rights, you know, for me, that's the most important thing. And that's, you know, absolutely our priority in the Fair Labor Division. We, you know, seriously want to end wage theft in this classification. We can't do it alone. We're looking to community partners, labor partners, partners in government, really anyone who's willing to work with us. You know, we're gonna respond and figure out how we can slow the tide. You know, stop wage theft.
Yeah, there's a lot going on around the state.
There's a lot going on all over the state.
Right. Thank you very much.
Thank you, Council Kane. The bad part of going last is, you
I'm good.
bad part of going last
Thank
is,
you, by the way, thank you for coming.
most of my questions are already asked and answered. And yeah, I want to thank you for being here too. It really seems to me that, and this isn't a criticism in any way, so please don't take it that, but that the work that you're doing at the AG's office is reactive rather than proactive. You're getting far more, you're being inundated essentially with complaints. So it's just about keeping up with the complaints at this point, investigating the worst of the worst and doing what you need to do to ensure compliance. That's concerning to me just as a citizen of the Commonwealth. I hope I was sent the wage misclassification material in the Senate bill that you had referenced earlier. I was sent it earlier this week. I was reviewing it, probably introduce something for my colleagues for us to show our support for that. But hopefully you can withhold some of the money that you get. I mean, I don't know if there's specific provisions in that bill for that, but so you can grow the division based on the actions. So it like a snowball rolling down the hill. The more guys that you find in violation, the more fines that you issue, you then are able to. It's like with the DA's offices and forfeiture money. The local police departments get something like 25% of all forfeiture monies. So there's a split there. So then that allows the police department to do more, to go after drug dealers more aggressively, and add to the drug dealer. And then we get more money for forfeiture. It snowballs down to actually shape public safety. And so I don't know if that's in there, but it would make sense to allow that to be in there, a provision that allows you to keep a percentage of the fines that people are paying in, so that we could get to a place in this state where this is proactive, where it's these folks are so these bad contractors, these shady outfits are so afraid of doing something illegal that they know that if they mess up, they're going to get caught. Because I think right now there's an imbalance in the system. The cost versus the risk of getting caught is off. They wouldn't do it if they knew they were going to get caught and they knew they were going to get hit with a fine. They wouldn't do it. They wouldn't do it if we didn't have these systems in place where they essentially go through loopholes by forming an LLC and then disbanding the LLC, forming a new LLC, the same guy, the same company, and doing the same thing in a different city because no one notices. And they get away with it here, they get away with it there, maybe they get caught once. They got away with it 5 times, and it makes up for the one fine they had to pay. And I think that's really what the problem is. And this legislation that we introduced here that we're considering one of the pieces sets a condition, and we'll talk about it more at the next hearing, but it sets a condition on any special permit that we issue as a city. So the planning board, the city council, we issue a special permit, it carries with it a condition that essentially the general contractor, the prime contractor, or any entity functioning in any capacity as a subcontractor or in any tier who's performing construction on the property is liable under this special permitting provision to meet every one of these, the wage classification, the wage, the misclassification of employees, and if they're not, if anyone in the entire tier, from general contractor down to the lowest subcontractor on the job, if they're found to be in violation of anything, the whole project shuts down, and that the city can issue a stop work order. Which I think maybe 2 other communities in the Commonwealth have that, where the city itself can issue the stop work based on some of the violations and some of the things that we were talking about tonight. So it'd be great, much better, make our jobs easier if that was done on the state level. But today it hasn't been done, so I think it's far too often falls upon municipalities to kind of lead the way and get it done in some of the bigger cities, and then the smaller cities follow, and then the state legislature says, oh, well, half the state's already doing it, so it can't be that bad. Let's pass it or whatever their situation is. Then also, you were talking about the lowest bidder, the bidding process, and what Quincy could do: check references, inspect that they are responsible employers, check payroll records. we have the same problems you have, where we don't have a full-time person who can just do that. And that's, that's one of the issues here, same as the state level and the local level. And I think when we went to this, I don't know when it came into place in the state, this the lowest bidder rules and laws, it was obviously to save the taxpayer money. And in that respect, it does a good job. But in the respect of getting the best value for the dollar, I don't think it always does. I mean, you cited it yourself. This building, this is a public building. We're using taxpayers' money to fund it, and somebody was not following the rules, who was being paid in taxpayer dollars. And that, that is disappointing. That is, and we're limited in what we can do. We can report it, we can check the wage records, the certified payroll, and we report it and can shut it down. But more often than not, I think these things are happening underneath our noses. We don't really have an ability at a local level to do much about it. So those are all my questions. Yeah, I didn't ask anything. But I thank you very much for being here. Thank you to Attorney General Healy for allowing you to be here. Look forward to communicating with you in the future. And I feel like this is the moment I would give you some sort of door prize for coming to City Council, like a hat or something, and make Quincy great again. But I don't. So you just have to take my expression of thanks.
Thank you for having me, and I really appreciate the work that you're doing on this issue as well.
Thank you. Thank you. Okay. Next up. We have Julie, if you want to come on up. We have Julie Bauer from Atlantic Charter Insurance. One of the things that I wanted to do is, again, to give us a full understanding of this issue is I had reached out to some folks in the insurance industry. They put me in touch with Julie, who has a panel here of folks who are going to talk a little bit about how this affects the insurance industry. We're talking a lot about workers' compensation, is a big part of this, and the fraud that goes on with avoiding premiums for workers' compensation. So I guess I'll kick it over to you. Thank you for being here. We appreciate you coming and being willing to have a discussion with us.
Well, thank you for the invitation, and it's very timely because about a year and a half ago, the Workers' Compensation Rating Inspection Bureau Governing Committee created a subcommittee to deal with premium evasion. So the folks that came with me represent companies or interests who served on that committee, and including on that committee was labor. So we have a labor representative on the council. So we've kind of worked through some of the issues. We looked at what other states do. We looked at things we can improve in our own application, and the membership voted on it. It now goes to government, and government needs to review and approve it because everything that we do is highly regulated by the Division of Insurance for the rates and the forms, classifications, and the Department of Industrial Accidents on the framework. So I'd like to introduce the panel. Tony DiPaolo is with the Insurance Fraud Bureau. Dave LeBlanc is with Acadia, and Acadia is a big voluntary writer of construction business. I'm with Atlantic Charter. We're a big pool carrier, so we write the involuntary business that gets assigned to us. And Dan Crowley is with the pool, and they do the assignments.
Involuntary business sounds like my day job.
Sounds like a what?
My day job.
Yeah. So in order to kind of help you understand how the comp system fits into this, we thought we'd give you an overview of the workers' comp policy assignment and the flow of information so that you kind of understand there's a lot of moving pieces in this system. The key elements of the comp pricing and where employer fraud occurs. There are certain points along the way that are more susceptible to premium fraud than other places. Some of the most common employer fraud types and what are high-risk characteristics that we as pool writer and voluntary writers will look at. If a risk presents a particular set of characteristics, we're going to do a lot more investigation into them. And then Dan's going to talk about proposed changes to the pool application, document maintenance endorsement to address fraud risk areas. And Tony's going to talk about the Fraud Bureau process. So the one thing you should know off the top is As carriers, we're obligated, when we see fraud, we have to report it to the Fraud Bureau. So the Fraud Bureau, we report all the time. They get the information, they do the investigation. If it's going to be prosecuted, it then gets transferred over to the Attorney General's office for prosecution.
So if I can just jump in there, so where you fit in is,
We write the policies.
you write the policies, but where do you fit in with the AG's office? So you're kind of more at the.
We pay.
You pay.
We are a funding mechanism
Okay.
for both the Fraud Bureau and the Attorney General's office. So, Dave, you want to, we thought we'd kind of tag team this.
Sure, yeah.
Great, thank you. Happy to be here tonight. I'm on the slides that look like this if you're following along. So what I'm going to do is just take you through the basics of how WC policies are obtained, how the information flows between the parties, and how premium is calculated. So kind of just level setting on basics. And then we'll talk more about how fraud can come to be and what we're doing to prevent it and some of those challenges. So employers in Massachusetts, no matter what business you're in, really, you need to obtain workers' compensation insurance so that if your employee is injured, that they're compensated for their medical care and for wage replacement. So there's two ways to obtain that coverage in the marketplace. The first, and agents would work with an employer, is called the voluntary market. So I'm a voluntary insurance company. So an agent would come to us with an application, with a business, they're seeking insurance, they would present their claims information, I would make a decision based on how their losses are, their safety program, I might do an on-site investigation to see what their work practices look like, we'll look at their billing history, years in business, and we'll make a decision. If we decide to assume the risk, we issue a policy. If there's claims, we pay the claims. If a voluntary carrier decides not to insure that risk, the agent would then petition apply to the involuntary market, which is also referred to as the pool, and it's also referred to as the residual market. You hear those terms used interchangeably all the time. They would go through a rigorous application process, check information, and ultimately issue the same type of policy, pay claims, bill the premium, take care of injured workers. So that's kind of how it is. There's two ways to do it. The way it splits up right now in Mass is about 81% of the premium is insured in the voluntary market, and about 19% of the premium is insured in the involuntary market. In the construction segment, it looks a little different. It's almost 40% of the premium in the involuntary market. So it is a difference, for contractors. So that's kind of how the general process works to get insurance. Once if you look at the next slide, once policies are issued, we provide, whether it's the pool or voluntary carrier, policy information to the Work Comp Rating and Inspection Bureau, so a statistical bureau. They in turn send the information to the Department of Industrial Accidents, and that's where you're seeing reconciling, does an employer have insurance? And if they don't, that's where you're seeing stop work orders. They also provide a service on their website where you can go in and check a contractor to see that they have insurance, so it verifies proof, and they manage the uninsured injury trust fund. So there's information that flows from carrier to the WCRB to the DIA, and that works, I think, pretty smoothly. Look at the next slide, premium, kind of how you get to it. So the first thing to remember is that policy is issued prospectively. So you issue a policy on day one, it's in place for a year. When you issue the policy, you make an estimate of the payrolls for the coming year. During the year, business occurs, and at the end, your payroll will either be up or down, might be the same. And so what happens is that there's a premium audit that's performed after the policy expires. We have premium auditors who, most cases, go on site. They verify and look at payroll records, they look at claims experience, they look at certificates of insurance, they look at tax information, they look at all information that they can find to determine what the actual payroll was for the year and how to allocate that payroll to the various classifications, which determines rates, which determines the premium. So the three keys to the correct premium pricing are first classifying the business correctly. There are 483 different classifications in Massachusetts, and so, and each of them has a different rate. So a roofing contractor would have a rate nearly $16 per $100. A carpenter would have a rate at $8. If you're an office worker, it's like 8 cents. So there's variation depending on the hazard, depending on the experience within that class code. So that's very important, because if you misclassify, and the example I use, if you misclassified $100,000 of payroll and they classified it as carpenter rather than roofer, the change is almost $8,000. So that's a real cost. So a contractor working as a roofer, reporting as a roofer, competing with someone who's a roofer reporting as a general contractor, that's a big difference. Even just on $100,000 of payroll, you multiply that, if it was $1 million of payroll. So,
Can I jump in there?
yeah.
Would one contractor know how another contractor is classified under the workers' comp policy?
Not likely to know.
All right, so it's not that, so as you heard from the Attorney General tonight, the Assistant Attorney General, Mark, they're getting most of their information from workers on the job, other contractors who lost bids, who can't be as competitive, can't figure out why they must be cheating, and this is what they're doing, or general public kind of calling. This wouldn't come up that way because there's no way. You understand what I'm saying?
Yeah, I sure do. So as a voluntary carrier, we're providing the policy, we're issuing the policy with the rates and the payroll. If you're my customer, I send you a copy of the policy to you and your agent. You're the ones who have to look at it. It's not publicly available.
Right, so should you guys have investigators who look specifically for misclassification? Am I jumping ahead?
Yeah, a little bit. We're gonna kind of get to some of that.
Yeah,
So
all right.
let me just.
Sure. Gotcha.
And then the other thing too is if you're taking $100,000 of payroll that should be reported on the books and it's off the books, it's the same math. You're just avoiding the same kind of premium. And then finally, you'll hear about EMODs or experience modifications, experience rating factors. So the final piece of premium after rate times the payroll is based on the employer's actual claims dollars compared to an average for a similar type of business. A factor is calculated. If the factor is 1.1, it means that their claims experience is generally 10% worse than what you would expect from an average. And so they have what's called a debit mod, and they're going to pay more than a contractor who had a 10% better than average claims experience, who might have like a 0.9 experience mod factor. And so that's a 20% swing in your final premium based on your actual claims experience. So that's provided as an incentive to provide a safe workplace and to do things the right way. So once you end up with a debit mod, though, there's a motivation to find ways to escape the mod. That's another opportunity where we need to really make sure that we're enforcing correctly so that people really can't escape their own claims experience. So that's kind of the basics. And now we're going to kind of get to kind of the next pieces around how you can see fraud studies.
Thank you.
So the most common employer fraud is, as David mentioned, the misclassification of a business. They come in, the application comes in as carpentry. What we do is we go to the website, everybody has a website, and you see people walking on the roof, doing roofing. So we know that's misclassification. Misclassification of employees within a company. So if you've got manufacturing and you're classifying 50% of them as clerical, when they're actually on the shop floor, that's also employer fraud. And then the underreporting of payroll, paying people off the books, under the table, saying, $50,000 when it's really about $500,000. And as David said, avoiding it by changing your name, going out of business and showing up with the same management team, the same characters, but now you're under your wife's name or your brother-in-law's name. And this is another one, canceling the policy after you present a certificate of insurance. So one of the things that happens, the certificate of insurance is it's static. It's as good as the day it was issued. So if you want to check for continuing coverage, you have to go to the DIA's website to do that. And I know a lot of the construction companies do this. They have people full-time, that's all they're doing is checking and making sure that the certificates of insurance are still valid. For their subs, yeah, I mean, if you, like a good construction company, if you're not, you're not playing a game. So like I said, if those are the certain types of fraud, there are certain characteristics that make a risk higher, a higher fraud risk. So the independent contractor, especially those that have no payroll. So they're sole proprietor and they don't have any payroll, but they come in and they want to get a certificate of insurance. General contractors and subcontractors, trucking, delivery operations, temporary agencies or staffing agencies, risks that have multiple cancellations in the past, and risks that have no history. So if a risk gets canceled, notice goes, they can get canceled for noncompliance with the audit, they can get canceled for non-payment of premium. And if that occurs, as soon as that notice goes out, it goes to the Bureau and it goes to the Department of Industrial Accidents. And they've got 10 days to pay or whatever. And if they don't, the stop work order happens. And the BIA goes out and they shut down the job. And they can't go back to work until they come back and clear whatever the issue is, if it's payment or if it's an audit. They have to cure the audit before they can get back into the pool and get insurance. So we know this. We know what these risks are. But we still have a lot of frustration when it comes time to try to investigate and prove fraud. So at the time of application, the employer didn't have employees because, as David mentioned, this is prospective. So on January 1st, when they applied for the insurance, they didn't have an employee. Well, they hired 5 or 6 a month later, and they never told anybody. And one of those guys gets injured on the job. They submit the claim. We've got to pay the claim. So that will get caught at the time of an audit or a first notice of loss, that's what the FNOL is. Same thing with payroll. So at the time of the application, the employer really only had one job lined up. They've won a couple of bids since. They've never come back and adjusted their payroll, so they've not paid the correct premium. That also gets caught at audit and first notice of loss. Now, the first time, the second time, perhaps it slipped their mind and it was unintentional. The 5th or 6th, 7th time, it's a pattern. And so it's the insurance companies to no end. We conduct audits, so we go out, we do the interviews, we get all the records, and we depose the audit contact because we think we've got you. And it turns out that under the law, the audit contact, if it's not the business owner, we're out of luck. The business owner can claim I didn't know anything. The other frustration that occurs is that the class rate and the dollars lost are too low to justify prosecution. So we do the work, we build the case, we send it to the Fraud Bureau. They go out, they do the work, they do more investigation, they build a really good case. But if it's a low class, dollar-wise, or lower payroll, it doesn't get prosecuted because it doesn't justify. So the real rub with that, though, is that you need to be convicted of fraud to be debarred from public contracts. So no prosecution, no conviction, no debarment. Non-cooperation with the audit. This is a new tool that we got back in about 10, 12 years. So if we go out to try to do an audit and they say we don't have any records or, we're not going to meet with you, we try 2 times and then we can cancel. They cannot get a job because they get a stop work order, and they cannot get insurance in the pool until they satisfy the audit requirements. There is a loophole because they can get it in the voluntary market. So if there's an agent that's able to place that risk in a voluntary market, there's no mechanism in place right now to catch that. It doesn't happen that often. Usually if it's pool risk, it's in the pool for a reason. And it's going to come back and try to get reapplied to the pool. So with those as kind of our frustrations, that's why about a year and a half ago, the Workers' Comp Bureau got together and created a subcommittee and took a look at ways that we can tighten up our application and try to get more information on the front end to prevent employers from doing premium fraud. And so Dan's going to talk about what the different changes are that we've made. I would just say the caveat though, they haven't been submitted to the Division of Insurance yet. So these are just the working group's suggestions approved by the insurance industry, but until government signs off on it, they're just a work in progress.
Hello. I'd just like to circle back and answer one of the questions that was asked today about contractors being able to look and see what other contractors' classifications use. We did work several years ago with labor, and we designed a tool that's on the Department of Industrial Accidents website called the classification request form. So anybody can go on to that site through that link. There's an actual form that you can fill out, and it's really it's really a tool to deal with fraud. So it's going to be something you suspect fraud for, and what you can do is fill out that form and submit it electronically. And then what you get in return is you get the last 3 years policy information for that insured. But we don't give premium or dollar amounts per classification. What we do is do an allocation of payroll between the classifications that appear in the policy. So at least you can see what classifications are being used on that for that risk.
But I imagine that's not done anonymously, so sometimes people want to give their name in order to get that in.
Yeah, you have to give your email address and also, but we do not provide, we don't make a list public, but we process about 350 requests a year for that information. And just to go back, and as Julie was saying, last year our board set up a fraud subcommittee to deal with items that, when people are applying for workers' comp through the assigned risk pool. So I'll just give you a little the makeup of the pool. We write about 23.5% of the policies.
You're asking to speak up.
We write about 23.5% of the policies.
You go back there, Bill?
No.
You still can't.
Everybody.
Is this on?
Yeah, that's all.
Okay.
You just have to talk.
Yeah, we write about 23.5% of the policies in Massachusetts for workers' compensation. A lot of them, 40% of the premium that we write are in the construction industry. When we were dealing with the fraud subcommittee, it was pretty quick that 3 areas that we needed to focus on as far as types of industries were construction, staffing agencies, and trucking firms. As I stated, construction being the biggest item, we do see a lot. And also, one of the things in the pool, too, is I'll let you know, 90% of the policies that we write in the pool are under $5,000. So we're dealing with a small risk when they come into the involuntary market. So some of the changes that we've made to the application, because we only have one application currently that applies to all risks that are applying to the pool, so there's very limited information that we gather, and we actually end up sending back approximately 40% of the applications that we receive for additional information, and mainly the ones that we are sending back are related to the construction industry. So some of the things that came out of the fraud subcommittee was to create supplemental applications for trucking, construction, and also the staffing agencies. And I'll talk about construction today. What's very helpful to us when we get an application is to know what the website address for the employer is that's applying for coverage. We try to search for one, but if they have one, that tells a lot about what that insured employer is doing. So, if they come in to apply for coverage, and usually it's a one-word description that they come in with the application. As a carpenter, we can go on a website, we can find out that, they're also providing roofing, what types of jobs they're taking on. So that's very helpful. So we've added we ask that question, how long you've been, we'll be able to know if they say 10 years, we should find some type of insurance history so we can look into, how that risk is being handled currently, so we know how to handle it going forward. Some of the questions that we need to ask if we send it back. We also, if they're subject to a stop work order, we want to copy the stop work order attached to the application when we send it. The reason for that is, and a lot of people aren't aware that when you get a stop work order, there's a little box on the bottom that actually tells you how many employees they actually found working at the job site when they issued that stop work order. So we'll get applications in from someone and they'll say they had one employee. When in fact, if we get a copy of the stop work order, we can see that sometimes, there's as many as 17 and they're portraying it to be a very small one employee business. So that's going to be very helpful. What we're going to be asking for is some past history. As when you purchase workers' comp, you're really buying insurance for the future 12 months of that. So we're always focused on estimated payroll to charge that premium. So we're going to ask some questions as far as your past revenue numbers. You come in, you have $500,000 of revenue, and you only have 2 employees listed. That's a red flag right there. We're going to ask you some more questions related to the size of your business and how many employees you have. We're also going to ask not only for, as currently we ask for only the estimated 12 months of payroll going forward, we're also going to start asking for the prior 12 months of payroll that we've had, how many W-2s you've had on 1099 judicial, so we can, make sense of, if you had, 50 employees last year, how come you only have 2 this year? So it's all information that we're trying to gather just to try to make sure that when we issue that policy, we're issuing it accurately so that we can kind of ferret out some of this fraud activity that's going on. We're going to get copies of 941s. Those are going to be required in the application process, and we'll be able to have the attached forms that they're filing as far as quarterly wage earnings. And also, right now, we're going to require that the employer signs the application and that'll be referred to. So, we're also going to add a couple statements to the employer statement that lets them know right up front that both the assignment school and also the carrier that we're going to assign that business to is relying on the information that they submit on the application, and that allows us, as Julie was stating earlier, to cancel non-compliance or material misrepresentation if they relied on the application. They're also made it clear on the application that they also have an obligation, to notify the carrier that we assign them to let them know if they've changed their business activity or they've added employees or they're, changed their business activity. All information is going to help us service that policy more accurately going forward. And just to go back and just talk about some of the, costs that as an insurance, the workers' comp insurance industry in Massachusetts, we do provide, annually $4.9 million to both the Fraud Bureau and also the Attorney General's office to, to investigate and prosecute fraud.
Where does that money come from?
The insurance companies that write workers' comp in Massachusetts.
And that's because it's,
I'm sorry?
that's because it benefits you, right?
Yeah, that's we're
more
trying
time
to
to catch the fraud, you're
Absolutely.
recapturing premium, lowering your risk.
Yeah, we want to fight this game now, fight it.
Right.
And then also the Department of Industrial Accidents, every workers' comp policy that was issued gets assessed. The current assessment rate is 5.75 on the workers' comp rate, and annually they collect $70 to $80 million. That's used to fund the BIA, but it's also used to fund the workers' comp trust fund, which pays claims on employees that are employed by uninsured employers. And they also choose to investigate. There's a number of people talking today about the stop work order process. The DIA has a number of investigators that go out and both, check whether businesses are carrying workers' comp, and if they're not, they issue stop work orders. And they find last year they collected pass this on to Tony now to talk about the insurance fraud bureau.
Good evening. As said, I'm Anthony DiPaolo, Chief of Investigations for the Insurance Fraud Bureau of Massachusetts. Just for reference point for all of you, Insurance Fraud Bureau is a criminal investigative agency created by state statute. However, we are not like traditional law enforcement because we are privately funded, as Dan just said, by the industry. We investigate all lines of insurance, which obviously for here tonight is one of our areas that we look at is workers' compensation insurance. The
Russian FBI is also called the IFB, right? But you're not associated.
No, we're not. We're in the United States. We just took the FBI's letters and flipped them around. We get referrals from insurance carriers, law enforcement agencies, regulators, union representatives have also made a number of referrals to us. The general public, we have a 1-800 hotline system set up. We can also get referrals through our website. And then we will take that information, we process it, trying to decide which cases we will be most successful with. The cases that we actually work are cases that we will refer to the local district attorney's offices, Attorney General's office, and the United States Attorney's office. We work at all three levels of prosecutorial agencies that are available to us in the state of Massachusetts. The big factor for us is access to information. The more information we have, the more successful we're going to be on getting a prosecution done. And as Julie had mentioned, some of the blocking points on some of the cases that we have not had success on, it usually comes back to us not being able to get the information we need to put the case together. Because you have to remember, again, we are only doing criminal work. If we don't feel it meets the level of criminal prosecution, or our prosecutor does not feel it meets the level of criminal prosecution, the case unfortunately will die and go from there. What there are in place is a couple, just to give you reference points probably for you, we thought would be a good idea is a couple cases, highlight a couple cases very briefly that we've been successful with, and some cases that have not been successful, strictly on the workers' compensation premium fraud side. Recent past, we worked on a roofing contractor that had an injury of a worker who was not on the workers' comp policy. It was not picked up during an audit. It was picked up during the actual claim process because the claimant was saying that he was not getting his lost wages, his proper fair share from his workers' comp injury. The workers' comp carrier picked up on that. That they had not picked up this employee from a previous audit process. And then they also started to go back and look at who was using this particular roofing contractor, because they had the same carrier happened to insure a number of the general contractors who was using this particular roofer. It was determined that there was over $1 million of lost payroll, and we were able to get involved. We were able to compare the records together from the different carriers and the different contractors. And as I said, there was over $1 million in payroll determined, which was somewhere in the neighborhood of over $600,000 in lost workers' compensation premium. That contractor was convicted. They did have to make restitution back to the workers' comp carrier that was involved in that process. We also worked on a...
Can I answer that? Are they an LLC or is that private individual?
That was a corporation.
And so the corporation didn't simply declare bankruptcy?
No, they did not.
Pay the fine?
No, because it's a criminal proceeding, they cannot dodge that at all. If during a plea negotiation, if a decision is made to deal with the contractor as the corporate entity, right, fine. But most of the time we're going after the individuals because we're doing a criminal prosecution. We want to see somebody go to jail. Yeah. So, and that's the next we're going to highlight is scaffolding company. It was a union shop. What ended up happening, same idea. There was an individual that was hurt on the job. The auditor was going out to conduct an audit, found that the claimant was not on the payroll records, went back to the company again for a second visit. They made a mistake, gave him additional records that he shouldn't have seen before. The insurance company made the referral to us. We got involved. We executed a search warrant, and we found out was what the husband was a husband and wife operation. What they were actually doing was creating multiple sets of payroll records for whoever wanted them. In other words, there was one for the IRS. There was one for the workers' comp auditors. There was one for the union hall for their audits. And we ended up, they were convicted. They both did jail time in federal prison and had to make over $1 million restitution order. And they had to make, and part of their jail sentence was to make sure that they paid back $1 million to the Comcare, but also had to pay back to the Department of Unemployment Assistance, back to their fund too, because these people were, it was a cash payroll system. Now, we've also had cases that are not successful. We're not always successful. We actually looked at another roofing contractor.
You don't have to tell us what.
Well, I figured you'd give me perspective.
No, I'm happy to hear it, but you don't.
Okay, well, I can stop however you
You
want.
have to bare your soul to us.
Well, I just wanted to be fair. And it's up to you. If you want me to stop, I can stop and just take a question. Okay. We had another roofing contractor, same idea, where there was a claim picked up. We ended up getting involved. We were able to track that there was a very large payroll under the table payroll, cash payroll, independent contractors. Unfortunately, what happened was that the insurance company was not able to get in the door to actually conduct an audit. The actual written documentation that we need, the statements from the owners of the company, that did not happen, and we were not able to go forward on any type of prosecution, so the case was closed. We had another case where we actually did go forward, and as one of the points Julie had made, is we were able to track back, same idea, independent contractor payroll. They were conducting audits. The payroll information that was given during the workers' comp audits was significantly different than the payroll information that we were able to put together. We put together basically a case for prosecution, and the prosecutor declined it because they thought the dollar loss was not large enough to waste their prosecutorial resources. So we have a wide range of information there that, or cases that we work that we try to get done. And the last point I wanted to make is that there is, labor has access to a right to private action. It is Chapter 185 of the Acts of 2010, and the right to private action comes under Chapter 152, Section 25C, Section 11. And basically, any three people who want to get together to bring a civil action, in other words, it's civil, not criminal, based on preponderance of evidence, against a particular...
What's the action? What's the nature of the action?
Failing to, basically a cash payroll independent contractor system, a misclassification issue, not paying, and it's mainly, and because this is under 152, this is tied back to the workers' comp system, because that particular contractor has not provided the true information to the insurance company. Three individuals can get together and take action on behalf of the insurance company. The difference is if they go forward, the final judgment, if they win, goes to those individuals, not to the insurance company.
Is that utilized a lot?
No, it is not, but it is there.
I'm an attorney by day, my day job. Anytime I see any statute that includes attorney's fees, that's a rare thing.
Yes.
You sue somebody, you get your attorney's fees. That's not how it works. It's very rare instances where an attorney is compensated by the awarding of damages. So anytime I see it, it's always to me, we get paid, right? But so the reason why that's interesting, because clearly the legislature set it at a standard. The typical one is, that I can think off the top of my head, the main ones are violation of civil rights. If you have a claim for a violation of civil rights, you get attorney's fees. And if it's a 93A consumer protection, so if you're a consumer suing a business, you get your attorney's fees paid for. So it's, I mean, it shows to me, just seeing that, the elevation that the legislature put into this, that
Because
they're
the idea-
encouraging people.
Because the idea was actually to have workers
Right.
to
And so it wouldn't have to come out of pocket to pay for it.
agree. Right.
Yeah, and that's fairly new, so.
Yes.
It's
2010.
Yeah, that's interesting. And are the three people, they have to be employees, or is it three, anybody? So I didn't mean to interrupt you.
Nope, that's it. That was it. And we would take any, four of us will gladly take any questions from councilors.
Councilor Leanne. Thank you very much for your presentation. Thank you, Councilor Leanne.
Good evening. I want to thank you guys for being here tonight. I just have a quick question about, maybe it might not be quick, but a question about process, because again, this all circles back to what we can do as counselors to help facilitate the work that you guys are doing, and of course the Attorney General's office as well. So speaking to that, I just want to speak in the case of an example. So say, I'm a general contractor and I come into a project in Quincy, and I personally can't do the work myself because you have, the building of the facade, you have the utilities underneath in the ground, you have the electricians and all that. So say I get a certificate of insurance as a company that's bidding on this project to say, I'm licensed as a general contractor, but then I hire the electrician. Let's talk specifically about that part of it. So, say Councilor Harris comes in and says, I'm an electrician company, I can do the work for you guys. He has to then present me with a certificate of insurance that he is insured properly for the workers' comp. Is that correct?
Correct.
Okay, and so then he gives me a certificate of insurance and says, Nina, I have 10 employees, we can get this done within a month. And then I say, yes, I look through it, I give you guys a call as an insurance company, everything checks out, and then in that month, he hires 20 more employees, and then it comes back and he says to me, he gets rid of those 10 employees and then comes back and only has 10. Do you know what I mean? Like, does that tend to happen? And if it does, how can we, as either the general contractor or the city, I just want to understand where the sort of checkpoints are that we can make sure that that doesn't happen when somebody gets employed, presents the certificate of insurance to do the job, and then the job actually gets done. Do you understand what I'm saying?
Yes, I do.
Yeah.
Well, in the normal course of a workers' comp policy, what's supposed to happen is at the beginning of a policy year, true, accurate contractor would report whatever employees they have. So let's say in your scenario, they get, this electrical contractor gets a very large job and needs more workers. Well, they can at that time report that to the insurance company, let them know that their staff has grown. Or at the end of a policy year, the insurance company is going to go back out and conduct an audit to determine what the actual payroll was for that entire year. And then that will, in the normal course of the process, should pick up that information that that electrical contractor staff grew by 10. So it should pick it up.
So there is going to be a checkpoint whether it happens while the work is happening or at the end of the year, that the person that decides to skirt that process is going to get, basically in trouble for it, have to.
Yes, but in trouble would be, there's nothing wrong with if you get in the middle of a policy year, you get a new job and you need more workers. As long as you're paying fair by all the other rules, there's nothing wrong purely from a workers' comp standpoint. You go ahead and hire a larger staff to do a bigger job. And then you will provide that information to the insurance company at the end of the policy year during the audit process. I obviously gave you a couple examples where people don't play by those rules, but that is what's supposed to happen.
Okay. I'm just trying to understand some more checkpoints that maybe
Yes.
we can speak to developers about, or conversations that we can have as a municipality to tie in the work that you guys do, and maybe put some pressure on them to say, there are multiple checkpoints here. It's not just from the city side, it's not just from the police officers that are, watching the construction happen. It's not just from the AG's office. I want them to understand that this pressure is coming from all aspects of this. If they have to report that they're properly insured, then, it's not just coming from the insurance agency, it's coming from us too. So I'm just trying to understand some more areas that we can sort of put some pressures on to make sure that, the workers are insured properly and being taken care of.
The difference would be is if you're getting information from the workers who are getting paycheck cash, for 1 week's worth of work, that's the kind of information that should come to, gladly take it to the Fraud Bureau, go to the Attorney General's office, go to the Department of Industrial Accidents. There's a number of places that the information can flow through, and then we can investigate that. But that would be the difference if you start to have that information, what to do with it.
And I don't know if you can answer this, if Ms. Mark, if you can speak to this at all, but, say I were hired as a 1 week part-time employee, and somebody says to me, I just need some extra bodies, I just need you to come on this job site for 1 week, and, I'll pay you whatever this amount is going to be. Now, I have every right as an employee to say, okay, well, what about insurance? Even if I'm a part-time employee or a full-time employee, whatever the case is, right? And so we can encourage employees and folks in this room to share it with your colleagues as well, to say, when you get a job, ask about the insurance requirements, because then the person hiring you has to share that information with you, and now I, as the employee, can say, well, I can check with whoever I need to make sure that this company is valid based off of what they're offering for insurance.
You
Is
can
that
check to
correct?
see,
Do you understand
yeah,
what
when
I
you say
mean?
insurance, workers' comp insurance, yeah, they should go out, check to make sure there is workers' compensation insurance valid, there's a valid policy in place. But if it's a part-time worker, yes, if they were, if they were injured on the job, there would be workers' comp. As long as there was a valid policy in place, there would be a place for them to pick up on the insurance side. But then there's also a trust fund. So if they were hired by a contractor and were injured on the job, there's a place for them to go to, and that's the Department of Industrial Accidents.
All right, thank you. Those are just some. Thank you. Thank you, Mr. Chairman.
Thank you, Councilor Ian. That trust fund, is that fully funded?
Yes. Yes, that was something being brought up. It's a percentage of premiums that are collected in the state.
What I mean,
It's every year based on the need. So the Department of Industrial Accidents projects what next year's need is going to be for uninsured injured workers or secondary injury.
I'll just assume that the projections are good because you guys are insurance people. and that's
It's
what
not
you
us,
guys-
the state does it.
Oh, all right, so then I'll ask if the state's doing it. Is it on the projections? Do they
Yeah,
turn out?
pretty good, yeah.
Yeah, last year was one of their lowest claims. They only had 106 claims filed through the uninsured fund. So
And there's a workers' comp advisory council, which is made up of labor and business, and then there are certain governmental agencies that have a non-voting seat on that council. They meet the first Wednesday of every month, and they go through and they talk about the number of work orders they've issued. We talk about what the wait time is for hearings and all that stuff. So I know labor has like 2 or 3 seats on that. In fact, one, I think the labor rep is the chair of the issue. They bounce back and forth between labor and business with chair. But that's also a good source of info.
Good. Councilor Harris.
Thank you. Thank you for coming, folks. Great presentation. Cancellation, for instance, the cancellation of the policy after the certificate of insurance is presented to, for instance, the city on a project. There's no checks and balances. For instance, just like people who insure their cars, people who insure their homes with their mortgage companies. For instance, they cancel, and is there any checks and balances put in place where we would be notified that they canceled their insurance?
yeah, what happens is we actually give the Department of Industrial Accidents, they have a live feed into our system, so they have the ability to go in and if they check any business in the state, they can go into our system and check if there's workers' compensation. We also send them a monthly report that lists every cancellation that wasn't reinstated. So they get a list to work off of that shows all the insureds that were canceled.
And they'll notify, for instance, the city if there's a job.
Well, I don't know if they're going to notify the city.
Is there any notification?
But what they do,
set up?
That's why I said it's a static document.
Right.
The way the system is set up now is the onus is on the receiver of the certificate
Right.
to check it every day. Ideally, you want to get to a situation where the certificate holder would be notified of the final cancellation. But the state is not set up for that yet.
but the
Yeah, it is burdensome.
Yeah, and the DIA uses that report to be sent over for compliance checks, so they will call and issue, letters to them to ask those companies that were canceled to actually provide them proof of coverage, and if not, they'll well shut them down.
Thank you.
Thank you.
Thank you, Councilor Harris. Anybody left? Councilor Finn.
Thank you, Mr. Chairman. I have to thank you folks for coming in this evening. This has been a real education in many respects. I guess the one question that I just want, presenting the proposed changes to the pool application that you've presented, that's emerging because of this phenomenon around misclassification and other types of fraud.
That's right.
Correct,
Yeah.
related to
Yep,
this.
that's right.
And it's interesting because all of these particular things that you're proposing as a way of trying to address that or control that presently don't have operative today, which is really interesting. And the thought just that occurred to me is that when you're giving the breakdown between the voluntary carriers and the pool carriers, so to speak, you gave out those breakdowns between 81% of the market being within the voluntary carrier and then about 19% pool carriers. But then when we get to the construction trades, you've only got, I think if I remember correctly, so there's only about 40% of the construction trades that are under the voluntary carriers. And I'm assuming is that, for lack of a better term, given the fact that they're underwriting it, do they have a better toolkit available to them in terms of assessing risk, so to speak?
Yeah, what I stated was 40% of the premium in the pool is construction related. And again, the majority of the policies that we write in the pool are very small. 90% are under $5,000.
Okay.
Your larger insurance company, your larger construction companies is going to be in the voluntary market.
They are going to be in the voluntary market. Okay. So there's no connection in between the level of fraud necessarily that's taking place and where people are finding or securing their insurance.
Well, I think if you're a larger construction company, you've been in business for a long time, and you have a reputation. I think we're dealing with probably new businesses, less mature businesses. We do have performance series and standards in the pool that all the companies and service policies in the pool have to follow in regards to auditing. So if you have a construction policy with a certain amount of premium, not only do they have to go out and do a final audit, but they also have to go in and do a preliminary audit, after 3 months of the policy. So there are those checks and balances in the pool because we are dealing with usually businesses that can't obtain, and I'm not saying they're bad businesses, I'm just saying they're either small or they can't get coverage in the voluntary market, so we do scrutinize them.
And again, we may need to go back to talk to some of the folks from the trades, and I'm really just trying to
We're going to have it come up.
fully understand some of this stuff. But part of the whole problem that happens is there's so many tiers. It's not a contractor that they're oftentimes seeking a permit, it's a developer who's going to go out and hire a general contractor. And the general contractor hires certain subcontractors, et cetera, et cetera. So in many respects, some of that, who's being insured through that, very well could wind up within the pool carrier segment, et cetera.
Those different layers are all going to have separate policies. So hopefully they'll all have separate policies.
That's really interesting. But the bottom line is the costs for everybody involved are raised by those who cheat, essentially. And currently, the way the resources are directed, it's in such a way that oftentimes pursuing those who cheat, the cost benefit associated with that, makes it basically hard to enforce from what I'm hearing.
Yeah, and I think that was one of the reasons that they were pushed to get that civil right action, because they were frustrated, we were frustrated on the criminal side, because that's really what DOG's been able to learn from project.
Well, this process, I think, has been very helpful for us because, and again, this is not, and I know I can hear people out there who will say it already somehow, this is a union issue. It has nothing to do with that. This is a fairness issue. There's many reputable, non-union contractors and developers who do all that, who play by the rules. But those who are gaming the system wind up costing everybody else. And so it becomes a critical issue. And I think that we need to educate ourselves here as we keep moving forward, because what we're really trying to figure out, just as you say, the civil component helps strengthen labor's efforts to pursue some of these. We need how to better manage and enforce our own permits. We can write all kinds of stuff into a permit, but if we have no real solid means of enforcement, then it winds up meaningless. So the behaviors that we're trying to correct, we don't correct. So I just want to say thank you again, both to the Attorney General's office, but to you folks as well for taking the time to come in this evening and educate us a little bit to this. Thank you.
Thank you, Council Finn. Anybody else wishing to be heard? Questions?
Mr. Chairman. Thank you, Mr. Chairman. This is just a little bit off the record here, but a little bit on a little different note. How is workers' compensation claims? How many people try to beat the system by putting in a claim that actually isn't an injury? How often you get something like that, and beating the system that way? Open it up, and hey, listen, we have a $4,500 workman's compensation. Yeah, we're getting a lot of claims coming out of this actual cheating group of contractor. Is that happening?
You go ahead.
Yeah.
And just folding it after, hey, listen, we'll take a couple claims and.
Monday morning injuries, that might have been weekend. or-
Exactly.
No,
Exactly.
they do happen. You probably get on average about 200 referrals a year on claim fraud.
And I just wanted to kind of see where we're at with that. And I mean, that brings up the premiums, because now you get the costs in there. Brings the premiums for everybody else who works with comp. And that that pushes away some people who say, listen, I have to do $4,500 worth of workman's comp to do this. Is it really worth it, or do I try to beat the system? So I try to cheat. So that kind of relates, and it all kind of correlates together here on these premiums and where they're at. I know you have 106 this past year.
No, that was 106 claims that were filed in the workers' comp trust fund.
Okay.
For employees that weren't covered by the policy. Employer didn't have a policy.
That's it for me, Mr. Chairman. Thank you.
Thank you, Councilor DeBona. And just kind of wrapping up again, thank you very much for being here. The presentation that we received on the prior hearing had kind of spoken to some of the local examples of the underground economy, one of which was the 1400 Hancock project, which I believe is the West Chestnut. Redgate Real Estate, general contractor, Delbrook, subcontractor, Metro Walls, second tier subcontractor, Trinity. And they told us that on October 6, 2015, Trinity was disbarred from public work in Massachusetts after being operating without workers' compensation. So, I mean, this is something that's happening in the city of Quincy, and something that's happening in major municipalities all across the state. I think one of the things that you guys have raised earlier was that anyone can go on and seek the classification percentages, right? So I mean, that's something that the municipality could do. The city of Quincy, so say we have someone, on a regular basis who works at the city inspection services, they could go on, put in that request, and make sure that anybody's on a public job is properly classifying workers, right?
Yeah, what it's going to do is you're going to submit a form for that, ensure that you're looking for information on it. You'll get a report back showing the classifications that are on the policy, and also the payroll allocation on a percentage basis for each classification.
But so in a job like this, we have someone doing, I don't even know, but doing the wiring, right, the electrical work, right? And someone from the city, from inspection services, could go on, run that subcontractor, say they're subcontractor, run that subcontractor's information and make sure that their workers are properly classified, right?
That they have the classification on the policy. But I also want to clarify something. In construction, carriers can add classifications. It's not uncommon that a carpenter was doing like a kitchen remodeling job one day and then doing roofing the next day. So the carrier can add classifications if you found it audit. So there are, but in your case, the electrician's usually performing electrical services, so you would expect to see that classification.
So maybe that was a bad example, because what I was looking for is there a way in which the city, on a publicly funded job, in which it's a low bidder situation, on a publicly funded job, where the city can be proactive, or any municipality can be proactive and ensure that the classification is appropriate?
Yeah, you can look on through that classification request form, and you can see the classifications that are listed on it. If they're a steel erector, then you would expect to see steel erection classifications.
Thank you.
Then you might, that might be a red flag that you want.
Right, if they're all classified as office workers, we get a problem.
Exactly.
Right? A couple problems. Either there's a bunch of office workers building steel, or someone's not paying like they're supposed to. Well, thank you very much, everyone, for coming. I think that as we've learned more and more about this, I thank my colleagues, Councilor Finn and DeBona, for first bringing this to our attention and asking for a hearing on this. They asked for one, I've given two so far, I've given another one at the very least. But it's apparent to me after these hearings that I think there's more we can do. I'm never satisfied myself that maybe the global solution is on a state level, but for whatever reason the state legislature isn't taking action, and maybe for good reason, I don't know, but for whatever reason they're not taking action. And people tell me things, people ask me things all the time. Hey, can you fix this? Can you fix that? And I'll say, well, it's a state issue, really, but I work at the city level, so all I can do is control what's on the city level. And I think that's kind of what we're doing here. That we're taking action on the city level. So while this may be a solution that's better solved at the federal and the state level, it's a solution that we're going to seek at the city level because, again, I think that's our job here, is to provide some sort of solution. We can do that and lead the way for other municipalities and eventually the state to take action, and it's our responsibility to do so. And I think it's clear from these hearings that there's more we can do as a municipality to close the loopholes at the city level to root out those committing fraud. I think we can do more to combat against those not living up to the law and essentially hurting the law-abiding businesses who can't compete. You can't compete when your costs are real and someone else's costs are fake. And that hurts the employees of those law-abiding businesses, and it quite frankly hurts the taxpayers too. When ultimately we're awarding low bids, we're awarding contracts based on low bids that aren't true bids and that they're a violation of the law which exists to uphold public good. So I look forward to continuing to work in this committee, taking recommendations that we heard tonight, some of the things that we learned tonight, creating additional legislation and continuing to have hearings on the legislation that's before us to try and enact something to really put Quincy at the forefront of this, and get to the bottom of this and try and close some of these loopholes. So without, no one else has any comment, questions, I want to thank everyone for coming out tonight. I want to thank the folks who came out to watch and show your support for what we're doing here. And with that, I will adjourn the April 28th, 2016 meeting of the Quincy City Council Oversight Committee. Thank you.